Welcome to our short video presentation on antitrust issues as it pertains to ASHRAE. The goals of this session are pretty basic, pretty fundamental. We're going to look at the basic understanding of what an antitrust action is and how it would impact ASHRAE. And of course, the most important thing that we're going to discuss is how do we avoid getting into an antitrust situation or even creating the perception that an antitrust situation exists within the work of ASHRAE. And so I know some of you are sitting there right now going, well, wait a minute here. Isn't ASHRAE a nonprofit organization? Aren't we a 501c3? Why do we even have to worry about antitrust? Well, in point of fact, we do have to worry about antitrust. And antitrust litigation, if brought by the government, can generate huge costs to defend. On top of that, of course, it takes a tremendous amount of time, not just by staff, but by volunteers as well. And of course, the most critical aspect of it is the public perception of an organization that is operating under a antitrust litigation. It is nothing that we want ASHRAE's name assigned to, so it's really critical that each of us knows how to avoid this kind of situation. Just a brief history of the Sherman Act. It was born, quite frankly, out of the robber baron part of our history, which was certain gentlemen in charge of railroads, steel, and coal, in effect, dominated the market to the detriment of the American people. And so the Sherman Antitrust Act came in the late 1800s to protect the consumers from a failure of the capitalistic system, when it failed to become self-regulating and created a situation of monopolies and other unfair competition acts. This point of United States history was so damaging and created such public ill will that it is one of the few pieces of litigation that the courts can assign treble damages upon conviction. For example, let's say a company was found guilty of antitrust and was fined $1 million. The court has the ability to treble those. And so you can go from a $1 million action to a $3 million action in the blink of an eye. This gives you some idea of how serious this situation is in the court system. So let's take a quick look at the Sherman Act. As mentioned before, it prohibits contracts and other agreements, and they're pretty liberal about how those agreements are put together, that restrains fair trade. So it includes price fixing, market manipulation, bid rigging of events that are clearly not in the public's best interest. There is a Section 1 under the Sherman Act called the per se that prohibits certain agreements regardless of their effect on the market. So what this means is that an individual doesn't even have to be proven to have adversely affected the market. It just means that the unlawful action had the potential to have an adverse impact on the environment. And so this is a pretty liberal view of how things can go. And you can see here in front of you some of the agreements that are particularly onerous and considered a violation of the Sherman Antitrust Act, including fixing of pricing, fixing of markets, agreements among competitors dividing markets and such. And as you read this list, you can start seeing in your mind how ASHRAE might inadvertently get involved in some of these actions through our standards writing process, where someone could make an allegation that a standard was written improperly and in effect gave certain competitors that were on that standards writing committee a competitive advantage not enjoyed by other competitors. And of course, that is exactly what we want to avoid. And our system is set up to make sure that it doesn't occur. But then if somebody abrogates the system or short circuits the system, we might end up where we have this kind of situation. And so you read about this in the paper. There's obviously Apple has been in this situation more than once, where they claim to have manipulated the market, as has Microsoft. They've faced their fair share of antitrust actions. Probably the most recent one that I read about in the paper is with Uber. The Justice Department there took issue with Uber meetings that include all of these independent contractors, and the allegation was made by having these meetings and discussing pricing that they were in effect fixing prices in certain areas amongst Uber drivers. That's about as simple and as easy a way as I can think of to get yourself in real serious trouble. Now, there is a section within Sherman 2 that talks about the rule of reason, and these are actually exceptions to the Sherman Antitrust Act. And one of them, of course, is legitimate trade association activities, under which ASHRAE would generally fall. There are others. You can have a legitimate joint venture that does not violate Sherman antitrust regulations. And of course, there are agreements between firms in non-competing functions that are complementary that are also not a violation of Sherman antitrust. But the one that really applies to us is trade association activities. And so there are some exceptions mentioned in the Sherman Antitrust Act that points out the role trade associations and engineering societies like ASHRAE have in our society, and some of the things that we do to better the human condition, including right standards. That's one of the things mentioned, and it's one of the things that ASHRAE is best known for as a standard writing body. We are a technical society, and we rely upon our expertise of our volunteers to make the standard of care for our industry. And so this is recognized by the Sherman Act. But at the same time, there is that potential to get into an antitrust situation if we don't adhere to our own standards writing process and to the agendas. It puts some burden on us to make sure that we are doing what we should be doing in a perfectly legal fashion. Section 2 of the Sherman Act prohibits some monopolization and anti-competitive conduct. Probably the most famous case here that you recall was Microsoft's Explorer, which they forced to have bundled on computers, and that, of course, has since been done away with. There are activities even today where people try to limit competition and create a market condition that is not conducive to the capitalistic free market system that predominates in the United States. Section 2 talks about anti-competitive means. Probably the best example that I personally am aware of is a concrete firm that was very large, very prominent in a community here in the Midwest, and they were charged with lowering prices below their cost in order to drive a competitor out of business. Well, it's a perfect example of the Section 2 condition under the Sherman Act. So it's used to exclude people from the market, or if they're in the market, make sure that they're not competitive. We need to keep our eye on those types of conditions as well. And then finally, we have the Clayton Act, which was passed in 1914, really to overcome some of the gaps, some of the holes that were in the Sherman Act, and it prohibits mergers that reduce unfairly the competition. Recently, a proposed merger between Comcast and Time Warner Cable. There's several going on right now. And the Justice Department frequently looks at these under the Clayton Act to make sure that they aren't trying to limit the availability of a product or creating a monopoly within a certain industry. Clayton Act also prohibits tying or exclusive dealing practices. Again, a perfect example of that was the original agreement between Apple and AT&T. It used to be you could only buy an Apple phone from AT&T, and of course that no longer is the case. So how can you get into trouble as an ASHRAE volunteer? Actually, it's more simple than you think, unfortunately. And so there are some rules that you need to keep in mind as you do the work of ASHRAE, whether you're on a TC or a standard writing body or whatever it is you are doing inside our society. Right at the beginning, there's absolutely no excuse whatsoever to engage in any anti-competition activity in any set of circumstances, much less within ASHRAE. So you cannot talk about dividing territories or allocating customers, or even the opposite of that. Is keeping a customer isolated. To control pricing or price fixing is obviously not allowed any more than it is to refuse to deal with a client from a number of your fellow competitors. So what is an agreement? Now this is where the Sherman Act gets pretty liberal. I mean, you don't need anything in writing. You don't even need a handshake. It's conduct that creates an anti-competitive environment. It's behavior that can be prosecuted. There doesn't have to be a paper trail, as one would presume in some other legislative regulations. So what can't you talk to your competitors about? Well, there's a full list of things that really the Sherman and the Clayton Act prohibit you from talking about. Prices, terms and conditions, capacity, credit standards, market strategies, who you will sell to, who you won't sell to. All those are prohibited activities and things that should not be a part of any discussion within ASHRAE whatsoever. The rule of reason violations, which pertain specifically to trade associations and engineering societies like ASHRAE. As you sit on these committees and as you put these agendas together, make sure that the agendas don't veer into prohibited areas under either the Clayton Act or the Sherman Act. Make sure that you stay to your agenda. Don't let the agenda wander off into areas that may be construed as a violation or even perceived as being a violation. Also, when you have these committee meetings, don't allow private meetings, of certain select groups to have a meeting outside the committee as a whole. That oftentimes creates perception that something is going on that really shouldn't. Of course, you want to make sure as you do the work of ASHRAE, the language you use, how you write that standard or the guideline or whatever, cannot be used in such a way as to impede competition. Sometimes that can work its way into a discussion in what looks to be an innocent fashion, but can end up being extremely damaging to our society. So here's some of the bad excuses one might hear as these issues crop up. Rationalizing the market or a strategic alliance. If it is dividing up the market, if it is restraining entry into the market, if it is trying to control pricing, it's just not going to work at all. The same thing is true on preventing unfair competition. That is not the role of ASHRAE. We are not the police, and nor should any of our standards or other documents allow that to occur. That is a quick review of the Sherman Antitrust Act and how it would apply to our society. I think the good news here is that we can be very successful in avoiding any of these situations. We just have to follow our own rules, which are clearly laid out in TCs and standards, and staying to the agenda, following our procedure. If we can do that consistently, we're going to be successful at avoiding any situation, or even the perception of a situation that would create an antitrust violation.